What happens if you die without a will in Texas? Dying without a will leaves your estate governed by Texas intestacy law rather than personal wishes. This can cause confusion and conflict for surviving relatives because personal preferences carry no legal weight. Texas law first determines whether an asset is community or separate property. Community property includes most assets acquired during a marriage, such as a family home, earnings, vehicles, shared accounts and retirement contributions. Separate property belongs to one spouse alone. It includes assets owned before marriage, gifts, inheritances and some personal injury awards, but it must be proven with clear evidence. Mixing separate funds with community property can cause them to lose their separate character. For married people with children from that marriage, the surviving spouse keeps their half of the community property and inherits the decedent's half. Separate personal property is split. The spouse receives 1/3 and the children share 2/3. For separate real estate, the spouse receives a life estate in 1/3 while the children inherit the rest outright. If there are children from another relationship, the decedent's half of community property goes directly to all children. The surviving spouse still receives 1/3 of separate personal property and a life estate in 1/3 of separate real property. When a married person dies without children, the spouse receives all community property and all separate personal property. Separate real property is shared with parents or siblings if any survive. Only when there are no surviving parents or siblings does the spouse inherit the entire property. Unmarried people with children have their estate passed to their children in equal shares under a system called per capita with representation, which also covers grandchildren if a child has already died. Adopted children inherit the same as biological children. Unmarried people without children have their estate passed to their parents, then siblings, and if no close relatives exist, the estate is divided between maternal and paternal lines or eventually goes to the state. Not all assets are governed by intestacy. Life insurance benefits, retirement accounts, payable on death and transfer on death accounts, property held in a living trust and jointly owned property with right of survivorship transfer directly to named beneficiaries. These designations override intestacy and a will, so they should be reviewed and updated after major life events to avoid unintended consequences. Relying on intestacy is risky. It eliminates the ability to leave property to friends, unmarried partners, stepchildren or charities, and it may appoint someone you would not have chosen to administer your estate or raise your children. Probate for an intestate estate is often longer, more expensive and more public than for an estate with a will, and family disputes may erupt when the law distributes property in ways that clash with what loved ones know the decedent wanted. For example, a surviving spouse may have to share a home with stepchildren, leading to disputes or a forced sale. These conflicts not only strain relationships but can also reduce the estate through litigation. Creating a valid will gives you control over how your assets are distributed, protects your loved ones and avoids costly disputes. An experienced wills lawyer can explain the Texas Estates Code, help classify property correctly and ensure that your instructions are clear. An attorney can also help align beneficiary designations with your intentions so that community property, separate property and non-probate assets work together. The compassionate team at Family Matters law firm PLLC provides guidance for residents of San Antonio and surrounding areas. This law firm is located at 926 Chulie Drive, San Antonio, Texas, 78216, United States, and it focuses on estate planning for families. To discuss your estate planning with a wills lawyer and secure your legacy, call 210-997-2914 today and speak with an attorney.